Welcome to literary and jury charge practice. Let's get started with some jury charge practice. Here we go. Ready? Gentlemen of the jury, the plaintiff filed this action in the district court of this county and alleged that on the 18th day of June, 1926, the defendant, in consideration of the annual premium set forth therein, delivered its policy of life insurance to Thomas M. Doolittle, deceased. That the face of the policy was $6,000 with a provision, however, that in the event of death from an accident, the defendant agreed to increase the amount payable to $12,000. That on the 5th day of January 1958, said deceased, Thomas Doolittle, died by reason of an accident. That the plaintiff furnished the defendant with proof of death, affidavits, certificates, and statements of parties having knowledge or information concerning the same, and made demand upon the company for the payment of the total sum of $12,000. That on or about the 15th day of March 1958, the defendant paid the plaintiff $6,000 by reason of the execution of the policy, with the understanding, however, that said payment would not preclude the plaintiff from prosecuting a claim against the defendant for the sum of $6,000. That the defendant refused to make further payments, and plaintiff prays judgment for $6,000, payment of which she claims is due under the terms of the policy. All right, now let's try some literary material. And this literary is regarding test taking and test taking anxiety, and some good tips for conquering that. Here we go. Some anxiety is normal and often helpful to stay mentally and physically alert. When one experiences too much anxiety, however, it can result in emotional or physical distress, difficulty concentrating, and emotional worry. Wow, that's pretty scary stuff. Does this sound like you on test day? Whether in school or taking a skills test, your brain takes over, scares your body half to death, and suddenly you're paralyzed. You can't remember where to put your fingers, how to use that machine in front of you, or even when and how to breathe. What's interesting about test anxiety is that it is a learned behavior. We aren't born afraid of testing or fearful of a subpar performance on an exam. Rather, we acquire this response from those around us, much like we learned to speak and act in various situations. We follow the example set by others. Can you recall a time in your life when someone you admired demonstrated a fear or anxiety over a test or upcoming event? Even comments or well-intended encouragement from our parents or another authority figure at a young age can cause an undesirable response to certain events, such as a test. Do you remember how stressful the SATs or ACTs were when you were in high school? Do you think that stress was self-imposed, generated by outside sources, or perhaps a little of both? We'll continue on with that in a bit. For now, let's get back to some jury charge practice regarding insurance. Ready? The defendant answered and denied generally the allegations of the petition and admitted that it was engaged in the life insurance business in the state of Alabama and issued the policy of life insurance on the 18th day of June 1926 to the plaintiff herein, and admits that proof of death and other data in the form of affidavits, certificates, and statements were furnished by the plaintiff to the defendant, but alleges that said statements are insufficient to establish that the deceased died as the result of an accident, and denies that the plaintiff is entitled to recover any amount, and asks judgment for its costs. That concludes that jury charge. So let's start this one, and the subject of this jury charge is condemnation proceedings. Condemnation proceedings. Ready? If the issue in this case is the constitutionality of the statutory provision made for taking the property. Its constitutionality seems clear. If, as I assume to be the case, the issue is the constitutional sufficiency of the statutory 10-day notice by publication of the hearing to assess the compensation for the land taken, I consider such a provision to be within the constitutional discretion of the lawmaking body of the state. In weighing the due process of condemnation procedure, some reasonable balance must be struck between the needs of the public to acquire the property and the opportunity for a hearing as to the compensation to be paid for the property. Just compensation is constitutionally necessary, but the length and kind of notice of the proceeding to determine such compensation is largely a matter of legislative discretion. The minimum notice required by this statute may seem to some to be inadequate or undesirably short, but it was satisfactory to the lawmakers of Kansas. It also has been upheld by the Supreme Court of Kansas and the United States Court of Appeals for the 10th Circuit. Excuse me. Let's practice some of the words in this jury charge. We have constitutionality, statutory, constitutional sufficiency, constitutional sufficiency, condemnation procedure, legislative, discretion, legislative discretion, undesirably, All right, we will get back to that jury charge. Now let's do a little bit more practice on test taking. Here we go. The good news here is that we can unlearn this behavior, this frightening, incapacitating reaction we have toward skills tests. Overcoming test anxiety will take some time and effort, but you're already putting in time and effort preparing for those skills tests, right? So let's look at what things you can incorporate into your practice sessions that will help you tame the test anxiety beast. To understand how to modify your approach to testing, let's first take a basic human physiology lesson. Your brain is made up of neural pathways on which information travels to other parts of your brain and body. Much like a hike in the woods, the first time or two that you use a path or blaze a new trail, the going may be slow while you remove obstacles from your way. But the more you walk that path, the more trampled down the trail becomes, the wider it is, the easier the walk, and the more people can use the same trail. In other words, you widen and strengthen that trail just as you widen and strengthen a neural pathway. Let's take a look at a few of the words that we had in this section here. Incapacitating, anxiety, physiology, neural pathways, obstacles, All right, some words to practice. Let's get back to our jury charge on condemnation proceedings. Ready? To proscribe it as violative of the federal Constitution fails to allow adequate scope to local legislative discretion. Accordingly, while not passing upon the desirability of the statutory requirement before us, I am not ready to hold that the Constitution of the United States prohibits the people of Kansas from choosing that standard. Particularly, I am not ready to throw a nationwide cloud of uncertainty upon the validity of condemnation proceedings based on compliance with similar local statutes. Since 1889, it has been settled that notice by publication in condemnation proceedings to take and to fix the value to be paid for the land of a non-resident comports with due process. I agree with the court below and with the opinion of the Court of Appeals for the 10th Circuit rendered in the comparable case of Collins versus Wichita, which came to our attention at the last term of court and in which certiorari was denied. Therefore, I would affirm the judgment here. Some words to practice from this part of the jury charge. We have certiorari. I'm sorry, I'm not saying that very well. Certiorari, that's spelled Certiorari. Definitely a challenge. There's probably a brief for that one. I don't have a brief, but that would probably be a good one to have a brief for. Proscribe, instead of prescribe, proscribe, Proscribe. Nationwide cloud, a nationwide cloud. All right. Definitely some more words to practice from that jury charge. And that will conclude our literary and jury charge practice.